Imagine living in an apartment with no heat in the middle of winter, rats running through the walls, plumbing that doesn't work, ceilings that leak, and over 1,500 documented violations of basic housing codes. Now imagine your landlord showing up and trying to evict you for not paying rent for that apartment. This actually happened. And the tenants who fought back didn't just win their case. They changed the legal rights of every single renter in the United States forever. This is the story of Javins versus First National Realty Corporation, the court case that created the implied warranty of habitability. Welcome to Plain Verdict, where we break down the legal concepts that affect your everyday life in plain language. No law degree required. Today we're doing something a little different. Instead of just explaining what the law says, we're going back to the moment the law changed and telling the story of the ordinary tenants whose fight in a Washington, D.C. courtroom created protections that millions of renters still rely on today. It's 1970, Washington, D.C., a working-class neighborhood called Clifton Terrace. The tenants living in the apartment buildings owned by First National Realty Corporation were dealing with conditions that were frankly shocking. Housing inspectors had documented over 1,500 separate violations of Washington, D.C.'s housing code. We're not talking about minor cosmetic issues. We're talking about no heat during winter months, broken plumbing, rat and roach infestations throughout the building, structural damage, dangerous electrical systems, conditions that no human being should be expected to live in. And yet the tenants were still being charged full rent every single month for these uninhabitable apartments. To understand why this case was so revolutionary, you need to understand what tenant law looked like before it. For most of legal history, rental law operated under a principle called caveat emptor, Latin for buyer beware. Essentially, once a landlord handed over the keys, their legal obligations were largely done. Tenants were expected to inspect the property before renting and accepted it as is. If the building deteriorated after they moved in, that was largely their problem. There was no legal requirement forcing landlords to maintain habitable conditions throughout the tenancy. Tenants had almost no recourse. And crucially, if a tenant stopped paying rent because their apartment was uninhabitable, the landlord could simply evict them. The law didn't recognize the connection between the landlord's obligations and the tenant's obligation to pay rent. They were treated as completely separate issues. The tenants of Clifton Terrace were about to change all of that. When First National Realty Corporation moved to evict the tenants for non-payment of rent, the tenants did something remarkable. For 1970, they fought back. Rather than simply accepting the eviction, they argued that they had withheld rent precisely because the landlord had failed to maintain the building in a habitable condition. Their legal argument was essentially this: a lease is a contract. In every contract, both parties have obligations. The tenant's obligation is to pay rent, but the landlord's obligation is to provide a livable home. If the landlord fails to meet their obligation, if they allow the building to fall into dangerous disrepair, why should the tenant be legally required to keep paying? It sounds logical and fair to us today. But in 1970, this argument had never been successfully made in an American court. The legal establishment considered it a radical idea. The United States Court of Appeals for the District of Columbia Circuit ruled in favor of the tenants. Judge J. Skelly Wright, writing the majority opinion, stated that a lease is not simply a property transaction, it is a contract. And like all contracts, it carries implied obligations on both sides. The court held that every residential lease contains what they called an implied warranty of habitability. This means that regardless of what the lease actually says in writing, a landlord is always legally obligated to maintain the rental property in a condition fit for human habitation throughout the entire tenancy. Not just when handing over the keys, not just when it's convenient, always. And critically, the court ruled that a tenant's obligation to pay rent is directly linked to the landlord's obligation to provide habitable conditions. If a landlord breaches the implied warranty of habitability, the tenant has legal defenses against eviction for non-payment. The two obligations are inseparable. It was a seismic shift in American tenant law. The impact of Javins versus First National Realty Corporation cannot be overstated. Within years of the ruling, the implied warranty of habitability had been adopted by courts and legislatures across the United States. Today, it is recognized in virtually every state in the country. It is the legal foundation underlying everything we covered in our video about things your landlord cannot legally do, specifically the requirement to maintain habitable conditions and make necessary repairs. Every time a tenant successfully withholds rent because their landlord refuses to fix a broken heating system, they are exercising a right that didn't legally exist before 1970. Every time a tenant avoids eviction by pointing to their landlord's failure to maintain the property, they are standing on the legal foundation built by the tenants of Clifton Terrace, ordinary working-class people who simply refuse to accept that the law didn't protect them. So, what does a 50-year-old court case mean for you as a renter today? Everything. The implied warranty of habitability means your landlord cannot simply ignore serious maintenance issues and keep collecting rent. If your landlord is refusing to address significant habitability problems, no heat, serious pest infestations, dangerous structural issues, broken plumbing, you have legal options. Document the problems thoroughly with photos and videos. Notify your landlord in writing, and give them a reasonable deadline to make repairs. If they fail to act, contact your local housing authority to trigger an official inspection. Depending on your state, you may have the right to withhold rent, repair and deduct, or terminate your lease without penalty. The tenants of Clifton Terrace fought for these rights in 1970 so that you would have them today. Use them. The story of Javins versus First National Realty Corporation is a reminder that legal rights don't appear from nowhere. They are won by ordinary people who refuse to accept unfair treatment and who understand that the law can be changed. The tenants of Clifton Terrace didn't just win their case, they changed the law for every renter who came after them. If you found this story as compelling as we did, subscribe to Plain Verdict. We cover a new legal concept or court case every week in plain language. And if you're dealing with a habitability issue right now, drop your situation in the comments. We read every single one.